Looks like everyone is ready. Mr. Lips, on behalf of WMG, if you would like to do a sound check quick.
No, I cannot hear. You need to turn your mic on probably.
There we go. Testing, 1, 2, 3.
Very good, thank you.
Thank you, Counsel.
Okay, and now I believe it's going to be Mr. Kaplan. Is that correct?
That's correct, Your Honor. Phil Kaplan from the Anthony Oslin Law Firm on behalf of NCJC.
We can hear you well.
Thank you, Counsel.
Thank
Okay.
you.
We will begin with Mr. Lips on behalf of WMG.
May it please the court, counsel. My name's Tom Lips. I'm an attorney in Algona. I represent WMG LC, who operates through a court-appointed receiver, an attorney named Larry Ide in Mason City. We're here today. We think the Court of Appeals got part of its decision right in its interpretation of the Brockhouse case. We think the Court of Appeals got it right when it said it stood for the proposition that Iowa Code Section 677.10 prohibited the plaintiff, which was NCJC, from recovering post-offer offer to confess attorney fees because there was a statute, Iowa Code Section 625.22, that taxes attorney fees as costs. But we think the Court of Appeals erred by not applying that same reasoning to WMG's post-offer attorney fees, and we think we urge that the court erred by not granting WMG its post-offer attorney fees.
But doesn't that require that WM be a prevailing party, or can you have two prevailing parties in your view?
Well, we briefed that, Justice Waterman. If you look at Iowa Code Section 625.22, it doesn't say anything about prevailing parties.
It's tied to the contract, so you have to have a contractual right to attorney's fees, and the contract refers to the prevailing party shall be entitled, and the in context seems to be singular, and it was the tenant that got the jury verdict and would, by traditional definitions, would be the prevailing party, not your client.
Well, Ed, the short of it is, if that's the rule here, we suggest that it should be changed. I respectfully disagree with that analysis because Iowa Code Section 625.22 doesn't say that you need to parse the contract in any way. And if you look at the whole facts of this case, whether you call these good facts, bad facts, I call them extreme facts in this case. Under the extreme facts of this case, WMG should be considered the successful party or even the prevailing party.
I know the statute doesn't refer to the contract, but it does refer to the word costs, right?
Yes.
And there's no, attorney's fees are not costs unless a contract makes them costs. Is that correct?
I think in this case, Iowa Code Section 625.22 says that if the contract provides for attorney fees, then attorney fees are costs. And here, the contract did provide for attorney fees, so that's why attorney fees should be costs.
But I guess to Justice Waterman's point, it only provides for attorney's fees to the prevailing party. So if there's no contractual right to attorney's fees, I don't see how you get there. And I guess I would ask you, you said we should change the rule. What should the rule be?
Well, the rule in this case, in my view, we would urge that WMG should recover its attorney fees. Part of this ties in with Iowa Code Section 625.25. And if I got the statute written down right, it says before the plaintiff can recover attorney fees, the defendant has to have information of and a reasonable opportunity to pay the debt. And here, I'm going to go through the facts just briefly because I think the facts are important. And part of the deal is here there were 3 different lawsuits in a court-appointed receivership, and there's a little bit of ground clutter in the case, so I want to try and simplify it. But the short of it is, in this particular case, WMG really had no notice as to what the debt was pre-suit. They knew there was a claim, but they didn't know what the amount of the debt was.
Counsel, on that point, in 625.25, it refers to, a reasonable opportunity to pay the debt. Are you advocating that we analyze the debt as the demand made or the actual amount that is determined at the end of the trial?
Justice McDermott, I think both things are important, but the way I understand that statute, and I urge it should be interpreted, is, and I analogize it to like a notice of right to cure for a credit card or a mortgage acceleration. You need to tell the debtor what the amount is. And you can argue over whether or not there should be a little bit of wiggle room. But here, the claim was over $1 million, and the jury verdict was $41,000. And the first lawsuit that was filed in this case was before the debt was even due. Then it was dismissed. It was refiled. And still, the claims that were made, and I'm asking the court in this particular case to hold that the claims were per se unreasonable.
And this would be all or nothing. They wouldn't get any fees if we agreed with that position, right?
Yes, Your Honor.
And this statute maybe does the same, has the same or similar goal as the offer to confess judgment. It's to deter unreasonable demands that prolong litigation, right?
Yes.
Would this, but have we ever relied on or used 625.25 to bar an attorney fee claim?
Well, not in any cases that we cited. I recall when I just did some shepherdizing before I came here, I thought there was a case that said that giving a person only 2 or 3 days to pay the claim was unreasonable and it wasn't sufficient notice. If the court hasn't said that, one of the things we were going to ask here today is the court should announce such a rule. I don't really think that we're asking the court to change the law, just to clarify the rules here. One of the things that I think is important for these facts is, again, I'm representing a court-appointed receiver. He's an officer of the court. One thing we didn't cite in the brief, but it's in the appendix, I think it's pages 165 through 169, and if you can overlook a few typos in there, it was filed in the other case, Mr. Ide explains the problems that he's had. He's trying to wind this thing down, and he can't do it because of these unreasonable and excessive claims. And one of the big problems was this particular case. The debt was only $41,000. The plaintiff is making a claim for $1 million, and we call it the reimbursements claim. The plaintiff is making a claim for $190,000 in reimbursements that didn't really make any sense. One reason anybody who lives in rural Iowa would know this claim didn't make any sense, because the plaintiff was asking for $190,000 for a lease termination, and the rent was only about $130,000 a year.
It's the alleged debt is for the fertilizer or inputs or?
Basically,
Okay.
that supposedly carried over.
And your client gained possession of the land, so wouldn't they have had some ability to kind of assess what a reasonable amount would have been for these fertilizer inputs? Kind of make a reasonable estimate?
Well, conceivably, if you hired a scientist to try and analyze the soil, but NCJC, and we've cited it in one of the briefs in a footnote, they're a cutting-edge consulting firm that can calculate what this stuff is worth. They had all the records, and the first set of records that they provided us made a claim for $190,000. So how is a court-appointed receiver who has to get settlements approved and adhere to court rules, get a $190,000 settlement approved on a $41,000 claim? So that was part of the problem. The other problem was there was about a $900,000 other claim that was tied into this thing that couldn't be paid. Now, I think one important thing for the court here to know is, as soon as the receiver got, and it still wasn't accurate information, but NCJC reduced its claim from 190 on the inputs to about 74, the receiver within 4 days offered to confess for $75,000. So this receiver was motivated to pay just as soon as he got some accurate information. Now, there's one other thing in here that we didn't cite in the briefs, but I think it's important. You know, if you look hard enough in the record, there's been some interesting legal personalities involved with this case. And on pages 15 and 16 of the answer that was filed in April of 17, the prior attorney for the corporation, for WMG, pled in there that we've asked for information on these crop inputs, and NCJC just hasn't provided them. Now, they finally provided them when I was involved in response to an answer to interrogatory, and we have that attached to the application for further review. But that was really the first time that we could even get our hands around this thing, and it was still more than what the jury verdict was.
And Section 625.25 refers to before the lawsuit. So how do we clarify it? If it's a sky-high demand, they don't, as ultimately determined by a much lower jury verdict, you don't get any attorney's fees or?
Your Honor, yes, I think that should be the rule. The short of it is, if you look at the record here, this is a family legal problem that's being litigated under the disguise of a business legal problem. And if we'd have had this rule that announced by the Supreme Court, this receiver would have had a lot easier job trying to get this thing wound down. This receivership is tottering on bankruptcy. He's trying to get it wound down, and he hasn't had much help at all with Iowa Code Chapter 677 or 625.25 to try and shut this thing down. It's encouraged NCJC to, take unreasonable positions here to try and basically bankrupt this receivership. If this was a true business dispute.
But here's the thing. I mean, it strikes me some of what you're arguing can be taken care of within the statute. So part of the issue is they demanded a lot of other debts that they weren't entitled to. When we talk about the debt, which is the inputs, apparently that number was considerably overstated. Is that the issue?
They were both overstated. The one was, Justice Manfield, they were both part of the contract. And the $900,000 was thrown out on summary judgment, but the reimbursements itself were unreasonable. It was 4.5 times the jury verdict. Now, to show what our state of mind was, our client, they wanted to pay. And they offered to pay it, as soon as we got some information. In fact,
But
You
it
know, Mr.
strikes
Idoff-
me that the statute shouldn't foreclose somebody from saying, I've got this claim, this claim, this claim, and this claim under the contract, and here's the backup for each. And if you lose on several of those claims, maybe you get the fees disallowed on those claims, but you don't get all fees disallowed. You still prevail on the one you get fees on that claim, as long as you gave a reasonable estimate to the other side. Doesn't that sound like a logical application?
Well, I'd respectfully disagree with that, Your Honor. We cited all these cases. How am I doing for time here? I'm having a little,
14 seconds.
okay. Well, I'll try to talk fast.
She'll give you extra time
Okay.
if I ask her, if I beg.
Well, some of those cases that award fees in the briefs, they're, promoting public policy like civil rights violations or employment violations where the court's trying to better society. Again, here, we got this family dispute that's being litigated under the disguise of a business dispute. There was no social purpose. Everybody's got a right to their day in court, but there was really no social good that came out of this case. It just, we got a lot of legal fees, and now Mr. Ide, the receiver's got to figure out how to pay everybody. So I respectfully disagree with what you think the conclusion should be in this case as far as awarding fees, Judge.
Some questions.
Thank you.
Thank you. Mr. Kaplan.
Thank you, Your Honor. May it please the court, Phil Kaplan on behalf of NCJC. After the jury entered a jury verdict for NCJC in this case, the party's contract and Iowa law required the district court to award fees to NCJC as the prevailing party. The district court did what it was supposed to do. It awarded fees to NCJC and denied fees to WMG. The district court then properly exercised its discretion in setting the attorney fee award amount for NCJC. There is no legal basis to overturn the district court's attorney fee award in this case. The Court of Appeals erred in deciding that some of NCJC's fees are not recoverable.
So what is the reasonable opportunity to pay the debt that you gave the other side? Describe for me as succinctly as you can the reasonable opportunity to pay the debt you gave them.
Sure. Before the lawsuit started, NCJC provided a written demand to WMG to pay this inputs reimbursement claim. And it provided a calculation of the inputs reimbursement claim. It was
Could you use numbers? What number did they ask for?
It was roughly $190,000. And you can see the calculation in the appendix, page 319. And you can also see the date on the document at the top. It was e-filed on January 9th, 2017, which is before this lawsuit started. So there was notice of the debt, and there was notice in other ways too, that the contract provides for these reimbursements. The parties discussed this reimbursement issue in one of the separate lawsuits, and then there was this demand, and the demand was for a specific dollar amount. Now, the statute speaks in terms of reasonable opportunity to pay the debt. First of all, reasonableness is a fact question that's best left up to the district court. It's not for this court to overturn that decision. And there is no per se unreasonableness rule that WMG advocates for here, and there shouldn't be a per se unreasonableness rule. It should be up to the district court.
Counsel, so I'm sure I'm following because there are a few different numbers. The $190,000 debt was the debt for this for the inputs. The $75,000 offer to confess, was it related to that debt or a different debt?
That was related to the inputs as well. So
Okay,
to
and
explain,
then-
oh, sorry.
And then the ultimate judgment was for $41,453.57.
Correct.
Okay, thank you.
And one thing I want to clarify here is at the beginning of the case, NCJC had basically two breach of contract claims. One was for the inputs reimbursement. One was for this right of first refusal that it claimed was denied. That claim was dismissed, the right of first refusal claim. But NCJC didn't seek any fees for that claim. It's only seeking fees for the inputs reimbursement claim.
Could you address whether, who is the prevailing party?
Well, the prevailing party in this case is NCJC. Prevailing party is a legal term of art, and it's included in the party's contract. And under Iowa law, and basically everywhere in the country, including the Supreme Court, prevailing party means a judgment is entered in your favor that changes the legal relationship between the parties. In this case, NCJC won a jury verdict for $41,000. That's makes it the prevailing party.
What about your opponent's argument that they won a dismissal of the right of first refusal claims, and they also ended up with a much lower, you got a lot less than you originally demanded on the input claim. Does that make them a prevailing party, or?
No, there's one prevailing party.
Okay.
That's what the contract says, and that's what the law says. They had that the right of first refusal claim dismissed. That happens in all kinds of cases where plaintiffs bring a variety of causes of action. Some are successful, some are not, but only the plaintiff recovers fees.
But then 625.22 provides that the contractual attorney fees are to be taxed as part of the cost. Does that then fold them in as costs under the offer to confess judgment statute?
No.
Why not?
So a few reasons. One is that there's no case law connecting those two statutes. Two, there's no evidence of any legislative intent to connect those two statutes. There's no law to suggest that 625.22 was intended to expand or change the definition of costs under 677. And in this case, 625.22 is not the substantive statute. NCJC didn't bring a cause of action under that statute. There's no cause of action provided under 625.22. And 625.22 isn't a fee-shifting statute. All it does is provide a procedure if the contract provides a right to fees. So you look to the contract first, and the contract speaks in terms of prevailing party, as you just suggested. You determine who the prevailing party is under the contract, and according to Iowa law and law across the country, defining what a prevailing party is. Then, once you've determined who the prevailing party is, the statute, 625.22, provides a procedure for entering the award. And there's a little bit of background there that I think would be helpful. There was a prior version of the statute that said when a contract provides for an attorney fee, the court shall tax attorney's fees as follows. And then it provided a list of equations, basically. And it would say the plaintiff gets 10% of the first $200, 5% of the next $150, and then et cetera, and at the end it said 1% of everything in excess. In 1980, the legislature decided we don't like that anymore. That's basically just telling the courts you're doing a ministerial act. You pass it off to the clerk, see what's owed, and they apply a percentage to it. It's just a math problem. The legislator said we want the court to have some discretion or judgment in setting the attorney fee amount and deciding for itself what is reasonable. And you can see this in the editor and revisor notes, which say the 1980 amendment authorized reasonable attorney's fees determined by the court rather than fixed percentages. That's the purpose of the statute, is to make it so the court decides what's a reasonable attorney fee rather than just a fixed percentage.
And is that how you distinguish the Brockhouse case, which didn't really have much analysis, but that was a fee-shifting statute, the condemnation statute, and you're saying that's different than just a procedure for enforcing or collecting on contractual fees.
That's exactly right. Brockhouse, Tilton, and Street are the three cases that are cited in WMG's brief, two of which involved the condemnation statute. One involved a public contractor statute. And all three of those cases involved a statute in which the plaintiff brought a claim under the statute, and then the statute itself provided for shifting fees, and the statute itself defined costs to include fees. We don't have that here. We didn't make a statutory claim, let alone a statutory claim under 625.22.
I guess I'm not sure why the legislative history is necessarily relevant to this 67710 issue. Whatever the purpose behind the change in the statute, it still provides that the attorney's fees are costs. And there's no evidence in any of the statutes that the word costs has different meanings in different statutes, is there?
Well, I'm not sure I understand the question, but I'll try my best. Under 677.10, it refers to costs only. It doesn't refer to attorney's fees. So you have to start with the premise that that statute is only a cost-shifting statute. It's not an attorney fee shifting statute. That's what Weaver, this court decided in Weaver. So then you have to decide, does 625.22 somehow change the definition of costs under Chapter 677? And there's no evidence of any legislative intent to do that, to change the definition in one statute to match the definition in another statute.
Why is it a change, though? The statute says attorney's fees shall be taxed as costs. So for the purposes of this statute and the way it's administered, costs are costs. And in this case, costs include attorney's fees under both statutes. Isn't that right?
That is not right. Under 625.22, it doesn't say that attorney's fees are costs, much less say that they are costs for the purposes of Chapter 677.
It says they're taxed as costs, correct?
They're taxed in the same way that costs are taxed.
What does the language of the statute say? It says they're taxed as costs, right?
It says they are taxed as costs.
Okay.
And my read on that is, and I think this is consistent with the legislative history, is that that's a procedure. This is how the fee is entered after you've determined what the fee should be, and after you've determined who the prevailing party is under the contract. So the contract provides the substantive right for the cause of action and for attorney's fees, not the statute. The statute doesn't somehow change who the prevailing party is under the contract.
Counsel, under 625.25, it would have required your client to provide a reasonable opportunity to pay the debt before action was brought. Do you agree that the debt is the 41,000 and change that the jury ultimately, or that the court ultimately came up with?
No, I'd say the debt is the reimbursements claim, and the reimbursements claim, the demand was for $190,000, and that was what NCJC believed the debt to be at the beginning of the case, before the case started, actually. And it believed that based on a reasonable calculation of the inputs, requirements, and based on the evidence available to it. And again, this reasonableness question is for the district court. It's not for this court to say that was per se unreasonable.
Didn't the jury come back and say that number should be 40-something instead of
The jury did
190?
decide that, yes.
Okay, so didn't the fact finders decide that that was not a reasonable number in a sense? That wasn't the right number? I'm hung up on the reasonable opportunity to pay as well. I think that's based not just on time. I think the other attorney mentioned it's kind of like a notice to cure. I think it's not based just on time, but also if you ask someone for $1 million and you give them their 10 days to pay and they can't pay it, that doesn't make sense if the final number ends up being significantly less. It's not reasonable that a person could ever meet that. So help me understand how your original claim, which was reduced by the jury, how was that reasonable for them to pay before, according to the 625.25?
Well, it is a reasonable opportunity to pay when we tell them what the number is and say, you can pay this off. They could have paid the $190,000 and paid off this debt.
How did you get, so I looked at the 190 and there's like a 7-year look back on these inputs under the lease. You can recover for fertilizer you put in 7 years before termination, is that?
I believe that's right.
Okay. So basically, as things evolved, how did you get from this 190,000 number to the 75 or the one, whatever it was, 41,000 that the jury ultimately awarded? I mean, what happened?
That's a great question. I wasn't involved in the trial court level. It's my understanding that there was a calculation of this $190,000, and then through the course of discovery and looking at some plat maps, somehow the number was reduced. And frankly, I don't know how the jury reached the $41,000 number.
Did the district court make a factual finding that the 190 demand before suit was reasonable?
I think you can imply that in the court's decision. I mean, the court didn't come right out and say it's reasonable. It said that 625.25 does not impact our analysis, and same with the Court of Appeals.
What meaning should we give? Under what circumstances would 625.25 kick in to eliminate a fee award?
Yeah, and we can look at this court's precedent to answer that question. In every case in which this court has applied 625.25, there are three common facts that don't appear here. Number one, they involved a bank loan. Number two, they involved a liquidated amount owed, where there was a specific contractual amount set forth in a promissory note or a mortgage loan agreement that said, here's what the debtor or borrower owes. There was no damages claim that was subject to dispute or possible reduction through litigation. And then the third common fact is that in each case, the bank made a demand before the lawsuit that was lower than it ultimately sought in the lawsuit. So the bank sends out a default notice saying, let's say, you owe us $10,000 this month, and because you haven't paid us that, you're in default. Then the bank goes to court and says, actually, we're accelerating the whole debt. You owe $1 million. So in those cases, the bank never gave the borrower the opportunity to pay the full $1 million debt that the bank was claiming was owed in the lawsuit. It was only saying before the lawsuit, you owe $10,000. Here we have the opposite situation. We have a situation where our number was reduced through the course of litigation, and WMG could have paid the higher number, and we wouldn't be here today.
Yes,
Now,
but counsel, isn't it true that the 190,000 was never the debt? I mean, it's never been found that that's the debt. That's your claim of what the debt was, but the debt is 41,000. Isn't that right? And they were never given an opportunity to pay that.
They were not given an opportunity to pay $41,000 to pay off the debt before the jury verdict. That's correct. But before the lawsuit started,
didn't they, if I have the facts right, didn't they offer to pay 75,000? So that they offered to pay more than what the debt was? Do I have that right?
yes, but we disagree about, I guess, what the debt should be defined as. But yes, they offered $75,000 before the jury verdict. So
your position is the debt was what you claimed.
yes, and for the purposes of this statute, yes.
So any claim, it's got to be reasonable, I take it, right?
Right. And from our perspective, reasonableness is up to the trial court to decide. It's not for this court to set per se rules on what is reasonable and not reasonable, especially in a case where the damages could ultimately be disputed, as they were in this case. It's not a case where you can look at a contract and say, we owe this liquidated amount.
I'm a little troubled.
That's what the statute was intended for.
Yeah, I'm a little troubled by the notion that this was a reasonable claim, 190,000, but yet it's not clear from the record how it was calculated. I mean, it's a number. It's 3-4 times larger than what the jury verdict was. But in order to be reasonable, I kind of want to see a kind of a method of calculation, how it was arrived at.
Sure.
You took a swing at it a little bit, but I'm inviting you to go back to that question, please.
Yeah, you can see the calculation on appendix page 319. It's a spreadsheet breaking down the $190,000 calculation.
Thank you.
One other point I want to make, and this goes to, I think, both of the issues here under 625.22.
You may wrap up.
Oh, I apologize. Under both statutes, the court still has discretion to reduce the fee award if the court feels that we acted unreasonably. And the court in this case did exercise its discretion and reduced the fees that we sought by more than 50%. So it's not like the court is handcuffed by the rules that we have advocated today. Thank you.
Thank you. Mr. Lips.
Thank you, Your Honor. I just kind of wanted to go through what I thought the court should do here. Number one, I don't know that there's been much for Supreme Court opinions on 625.25, giving notice to the debtor. Again, I get back to these like mortgage accelerations or credit card done notices. It's always, and maybe part of this is federal law, But you got to have the demand or the notice to be reasonably commensurate with what's due, or maybe even the exact amount. Now, I think the court's got,
This is a provision that's in kind of derogation of the party's contract. Your client, you know, is bound by a contract to pay a reasonable attorney's fee if it loses a lawsuit. It lost a lawsuit. I mean, you debate that, but let's say we find that. You're saying that it should use this statute to avoid its contractual obligations. So isn't that maybe an argument to interpret this statute somewhat narrowly?
I'm not sure if I understand the question, Your Honor.
I'm saying that you have a contract between two parties. Normally, parties can contract for what they want. Here, the law is, in a sense, restricting the scope of their contract.
Well, I don't know if it, Your Honor, I don't know if I agree with that. I don't know if it restricts the contract. It just tells the court how they're going to handle this when they award fees. And it just, in my view, I submit that it's good public policy that if you're going to sue on a contract, you give the debtor a reasonable approximation as to what's owed so they can decide whether or not they can pay it or should pay it. Now, what I was trying to say here to begin with is I think you got two choices here, or several choices. One is if the demand is per se unreasonable, there's no fees. I think that's what we got here. The demand in the claim was per se unreasonable. If the court wants to stop there, they can. And it resolves that issue, but there's an opportunity here to do a little bit more. You can say the claim's got to be the exact amount of the debt. Now, maybe the court doesn't want to do that, but that's another option. The other option is it needs to be reasonably commensurate with what is owed. Now, here we have, and I had trouble finding the footnote, but the footnote is in one of the briefs somewhere. NCJC was in the best position to calculate what was owed. They had the records. They were a portal-to-portal consulting firm. They could have calculated it and provided it. They chose not to. Now,
About having the district court make a factual finding whether the demand was so out of line that fees should be cut off altogether, and was there such a finding here implicitly?
well, the finding that they made, we didn't agree with. The finding was that the claim was reduced through discovery, which I don't see where that gets NCJC anywhere. It just goes to support what the receiver did. He wasn't going to pay this until he got some correct numbers, and the numbers that he ended up getting were still over and above what the jury verdict was.
But 625.25 refers to the pre-suit demand, so I'm not sure it matters much if they lowered their demand later, other than shedding light on whether the original demand was out of line. But
Well, Your Honor, I think I agree with that. The pre-suit demand was unreasonable. It was per se unreasonable, so I think that solves this case.
What do you make about the district court, or the argument the district court impliedly made a finding? I mean, there's no express factual finding in the order, of course. But there is reference to the statute and the suggestion that it didn't apply, which kind of, you heard the argument that it impliedly is a finding of reasonability. What's your view of that?
Well, it reminds me of a family law case I watched many years ago where both sides were asking for a modification, and at the end of the case, the district judge stood up and said, "I'm going to leave you where God flung you." I don't think he dealt with it, other than said it doesn't apply, and I think he was wrong. And the claim was per se unreasonable. I wanted to get to a couple other things. Am I out of time?
Yeah, you can simply wrap up. Thank
Okay,
you.
I'd like to wrap up. Prevailing party. In order to be a prevailing party, you have to have a lawsuit. And I submit 625.25 prevents WMG, NCJC from being a prevailing party. The lawsuit shouldn't have been filed because they should have provided adequate information ahead of time. Basically, this thing was jury rigged to get to a lawsuit so they could manufacture a prevailing party. They shouldn't be a prevailing party because they didn't comply with 625.25. That was one thing we hadn't talked about, and I wanted to make sure it was mentioned. So with that, I think I've made clear the relief that we've asked for in the briefs.
Thank you.
Your Honor.
The case of NCJC versus WMG is hereby submitted. The other cases, State versus Zacharias, and in the interest of CZ, are submitted without oral argument. And with that recitation, morning court is adjourned. Thank you.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.